have Professor Paulo. Okay, recording in progress. Okay, and today we have Professor Paulus class 2 to share his analysis of the future of the comprehensive agreement on investment between EU and China, because there has been some developments regarding that treaty recently. And Professor Castro is an associate professor at the Faculty of Law at University of Macau on a protracted leave of the University of Coimbra, which is the oldest and most prestigious, I'm sure, university in Portugal. He researched extensively on international law and EU law, and I'm your host, David Yip. I did my master in London on international studies and diplomacy, and currently I'm working for in public relations. And without further ado, let's welcome Professor Castro. Professor, please.
Thank you very much, Mr. David Yip. Allow me firstly to address my greetings to the Fortune Society, which kindly and very honorably invited me for this endeavor. And in particular, I permit myself to salute Professor Wu Mei, kindly extended invitation. And I'm also very pleased to be under your guidance, Mr. Yip. I do recognize a few friends in the list of attendees whom I would also like to salute. I'm very certain their insights later on shall be most welcome and enriching of these thoughts. And what I mean to do is really to share some, I would say, very preliminary insight into these very complex, but I would say also auspicious and meritorious agreement, which runs by the name Comprehensive Agreement on Investment. And as you know, an agreement which was adopted at the very end of the year 2020, and which, of course, as the name denounces, has an overriding objective, which is the one of facilitating investments by European Union companies in China, but also by Chinese companies in European Union. And for that, the means which was chosen is indeed the one of an international agreement, for which, of course, a certain negotiation took place, where expectedly there is a frank exchange on the expectations of the partners to be. The very title of the agreement also denounces that being an agreement on investment, it has a bit of another more ambitious scope. It is said to be a comprehensive agreement. We are going to see what this means. And then finally, we are going, I hope, to make an assessment. I want to venture a few ideas by means of a preliminary assessment of this very complex tool that we have in front of us. Of course, it is also important to realize where we start from. And of course, there is a belief behind this agreement, of which the two parties, the contracting parties, the People's Republic of China on the one hand and the European Union on the other, clearly share. And the belief is that investment can be a positive source of development for the societies which are involved. Investment can be a key for growth, economic growth. Investment can be a key for a topic that is becoming more and more important, jobs. Investment is crucial for attaining what is supposedly the agenda of this new century, sustainable development. And investment is a key for innovation. for bringing in new possibilities in terms of the very organization of society and responding to the needs of society. Very timely, at a time where, of course, we are in front of a major crisis, a major development crisis for humanity. We had already sustainable development as let's say, an agenda for the years to come, up to 2030. But there are other transitions more enduring, which are in the context, like the digital transition and the climatic transition, and the response, which shall be also a long-lasting one, of course, to the evils of the pandemic, the COVID-19 pandemic. I would like to remind that this happens in a context where we are witnessing, probably because these challenges are momentous, also an important rethinking of rules which govern today's global society. Rules which, of course, have an impact on the very departing points as well as expectations, and then finally the obligations of these treaties. I would like to recall that this agreement was very much shaped on the part of the European Union by the design of the so-called Trade for All strategy back in 2015. But on the side of China, of course, it also matches certain hopes which have been spelled out in different momentous summits of the leading authorities, in the context, for instance, of a new industrial policy, in the context of meeting a carbon-free society on the part of the European Union, supposedly by 2050, on the part of China by 2060. And this in a context where the rules on economic endeavors are changing everywhere. European Union is reviewing its agreements with most of its partners. Of course, these days, this comprehends also the United Kingdom, but it has been doing so. It has been under negotiations with Australia, with New Zealand. It has done negotiations with Canada, further away, with Singapore, with Vietnam, with Japan, also with the Mercosur, with Korea. And parallel to this, there is an agenda which should not be forgotten, which is going on, maybe in a slower moving pace, but still evolving in the WTO context. Now, in regard to the particular bilateral setting of the European Union and China, I think it is important to recall what was, and in a sense still is, the legal framework for investment, for addressing this problem between these two major trading economies, trading partners in today's world. I would like to recall that this legal framework was actually inhabited, if you want, by a very disparate number of investment protection agreements. Agreements between individual member states of the European Union on the one hand, and China, thus obtained before the European Union gained a competence for foreign direct investment back in 2009 as a result of the adoption of the Lisbon Treaty. At that time, there was a major development which occurred in the always evolving balance of power, if you want, between the European Union as a specific institutional setting, aggregate entity, and the European countries, which was indeed that the Treaty of Lisbon conferred on the European Union powers for holding an investment policy of its own, irrespective and actually consuming the individual policies of the member states. This, of course, has been object of a very important legal opinion of the Court of Justice of the European Union in 2017, which has struck a somewhat different balance in the sense that this investment policy does not necessarily absorb all the policies of the member states in regard to investment, but this is a fact which could not go without consequences. And this is the more important as these bilateral provisions on investment lacked really a sense of modernity as they used to exist, as they still exist. They lacked a sense of modernity, and in particular, they were not leading to investment liberalization. And of course, the overall 1985 EU-China Agreement on Trade and Economic Cooperation does not provide an answer for these aspirations either. The picture is actually really one where there are 25 very different bilateral investment treaties, which are generally outdated, which certainly do not reflect the developments in the European Union and China's investment policies and the shifts that both trading partners, if you want, had been experiencing both at the bilateral and the international, the wider international investment setting. I said it, these agreements are very diverse, but even the more modern ones only have very faint rules on what is called post-establishment national treatment guarantees, which ensure an equal treatment of an investor company which enters into a foreign market in regard to the domestic companies, competing companies. And on the other hand, the provisions for ensuring compliance and enforcement are very weak. By that time, China had already acceded to the International Center for Investment Settlement Disputes back in 1993, actually, and thereby had already gradually opened itself to granting access to investor-state dispute settlement. But this came with very tough conditions, which in fact permitted still a very clear discrimination in regard to the European competitors, foreign companies entering the Chinese market by means of their investments. It is telling, by the way, that in spite of these developments, in spite also of the fact that the rule of law is not considered to be a very, let's say, prominent reality, there was only one instance. Please notice this, one single case which had been brought to this dispute settlement system, and already in 2017, where one European company did indeed argue for, let's say, complying with certain standards under one of these agreements. So all the other topics which have already been there from the 90s in terms of modern topics related to sustainable issues, sustainable development, rules on state-owned enterprises, transparency rules on subsidies. There was no expression of this in the existing legal framework. Of course, I said it, China's position has been changing a lot. And it is also important to take stock of this evolution to better assess both the departing point as well as the ultimate result and the import of this agreement, I believe. And the major change, as far as I'm concerned, has to do with the fact that China used to be a capital importing foreign direct investment importer country. And obviously these days, it is a very important capital exporter as well. And I don't have, of course, to recall the Belt and Road Initiative to demonstrate this. There are other shifts. China is opening itself to another kind of economy, much more relying on services than on production and export of goods abroad. There are transitions which are very obvious to any Chinese or anyone living in China in terms of addressing issues of climate change, the tremendous development of China in the digital realm, and the ambitious state-sponsored industrial strategy of China, Made in China 2025, which have to have impact on this matter. And this translates into law as well, and as well as to its policies in regard to foreign partners. In regard to law, I would just like to recall that back in 2019, a new foreign investment law was adopted, one which entered into force in the beginning of 2020, which, to give just an example which nonetheless, I believe, gives you a full sense of the huge development which is at stake, prohibits for the first time forced technological transfer. And in this sense, represents a major change from traditional practices, which, by the way, brought some countries to go against China in the WTO settings. There were cases in the WTO dispute settlement system where precisely this particular matter of forced technological transfer for foreign enterprises entering the Chinese market were at stake. But these changes also affect the European Union. Of course, the European Union is still the major both exporter and importer of capital in the world, the major consumer, if you want, of foreign direct investment overall in the global market related to investment. But the European Union is also feeling the pinch of modernizing, if you want, its system, because it is involved in facing major challenges, the need for the transitions, the need for this making real this Green Deal that it professes, the need for the recovery program, the EU Next Generation program. All these shall require huge capital inflows for sure, as well as opportunities for further exporting capital in other venues and making it become profitable. And this also in a context where the European Union is changing its laws in regard to the governance of the international economy. I have already mentioned the Trade for All strategy. I could as well mention a very important one, its very new positions in regard to the established mechanism for dispute settlement in the investment realm. Instead of relying on the old 1965 Washington Convention for investor-state dispute settlement, which has given rise to this immense lawmaking in the 90s of last century, beginning of this century, and which has materialized in more than 3,000 international agreements abroad internationally, which indeed bring in adopt this ISDS system, the European Union is promoting an international an investment court system, which promises to shape the debate, if you want, in this area, and which is not theory anymore, because it has already materialized in agreements like the Comprehensive Economic Agreement with Canada, in agreements related to investment protection with Vietnam and Singapore. There are some discussions of these also in regard to Australia and New Zealand. For instance, to give you just an example, not to mention, of course, the ongoing WTO agenda on these matters. The fact is that the European Union, under this new policy, has been accrediting 4 main vectors in its international negotiations, in its reformed European Union approach in regard to investment policy. The first one is a clearly defined protection standards. And this departs from the old traditional, if you want, American template of fair and equitable treatment, which is very open and which gives much room for actually interpretation and then also dispute. The European Union is promoting other more definite standards for protection of investment. The second vector is that the European Union is systematically mainstreaming its ambitious sustainability agenda, including environmental and labor provisions, into these more specific investment agreements. The third vector, the European Union is trying to accredit a distinct provision on the right of every contracting partner to regulate, reaffirming the capacity of states or other entities to adopt measures in pursuit of public policy goals, including national security, when they clash with certain interests of private investors. For instance, environmental ones, for instance, social ones. It is a prerogative of the state, according to this rule, for the state to still be able to legislate anew on these matters for the sake of the public interest. And then, I said it, the European Union is advocating the replacement of the traditional ISDS system by a very complex 2-instance internet investment court system, which seeks to substitute this ad hoc dispute settlement traditional system with a multilateral, with the setting up of a multilateral investment court, which on top of all may also add in terms of reliability of its case law. Now, these, if you want, changes in the tectonic plates of the partners in their policies, both legal as well as economic, led to certain objectives, which of course impacted more directly the negotiations, which were the, let's say, specific objectives. What was the specific position of China when it started its negotiation, and which, against which I believe we should also assess the current agreement? Well, I would say that China had a very pragmatic approach, not too ambitious in a sense. It wanted to establish uniform EU-wide protection for Chinese investments. Instead of having 25, 26 positions, to have a uniform general protection for these investments in the European Union. A second specific objective, of course, to improve the legal certainty regarding the treatment of Chinese investors in the EU, to ensure that there would be a kind of lock-in effect, which also translates into preserving the existing openness in the EU to Chinese investment. The fact is that the European Union market is very open to both private and public enterprises, both domestic as well as foreign. It does not discriminate essentially between any of these entities. But the Chinese, of course, were also concerned against a certain backlash against investors for calls for control of foreign direct investment on grounds of national security or other public order vectors. The idea of some screening of the investment. Finally, and more palpably, China was seeking more favorable conditions in regard to visa, work permit requirements, intercorporate transferees of CEOs, technicians, people working for the Chinese enterprises located in the European Union internal market. European Union objectives were much more far-reaching, I would say. Some were of a more general nature, some other ones were more specific in scope. In terms of general objectives, of course, there was a general aspiration to foster and facilitate bilateral investment flows, to unlock what is seen as an untapped potential, particularly in regard to flows from the European Union into the very big Chinese market, if you want. But then there is a much also relevant ambition in regard to try to rebalance the European Union-China economic relations by means of reducing barriers to investment in China. There was this notion that China was still is still a very closed market to investment, irrespective of its gradual opening, and that this would be an instrument which would facilitate that. Also relevant to enhance the certainty regarding the treatment of European Union investors, to make sure that they would not be discriminated, as it is still very much an overall fact, to ensure that the principle of national treatment would govern, let's say, the legal status of European Union companies in the Chinese market. And generally, of course, to improve the protection of European Union investments in China. More specifically, and also innovatively, the European Union was seeking to support these investments as a means to enhance sustainable development, to encourage sustainable development, to make sure that this is a responsible investment, that it would be a means also for promoting some core environmental and labor standards. The attraction of the investment should not be at the cost of these standards, which the European Union is keen on. And then also to make sure that these all substantive provisions would be effectively enforced, that these commitments would stand a chance of becoming true, if necessary, by means of resorting to what the European Union aspired to be, a robust dispute settlement mechanism, both at the international level, state to state, if you want, or European Union to China, as well as investor state. Allow me just for, sorry. Sorry for this. I came to realize that I was running out of.
No worries, it's all right.
Oh, and I was worried that this might cut us. Anyway, the overall, underlying challenge to be addressed is indeed the major discrepancy between the overall European Union-China investment relationship. The European Union is, as a market, very open to foreign direct investment. China has consistently been evaluated by the OECD as one of the most restrictive markets. But this was what it used to be. Indeed, but one has also to recognize that in this, China was not abusing the system. It was a right of China to choose at that time. Why? Well, because still today, there is no such thing as a multilateral investment agreement. We all know that this was attempted back in 1995 in the context of the new WTO setting, but that these negotiations failed and were never resumed in 1998, precisely out of a clash between developing and developed countries. And that the only WTO agreement which somewhat addresses the issue in regard to services, which is GATS, does provide for a pick and choose possibility, which China has been using, I would say, very prudently. And so there is no more obligation but the one that China, let's say, took upon itself in the context of this general agreement on trade in services. Now, then we have, of course, the investment agreement itself. The history is well known, I believe. In a sense, it starts back in 2010 when the European Commissioner for Trade, De Gucht, meets with the Minister of Commerce, MOFCOM, of China, Chen Deming, and they decide to set up a joint European Union-China investment task force where the discussions all started. And eventually, this came to the more authoritative political level. And in the 16th European Union-China Summit, when the 2020 Strategic Agenda for Cooperation was adopted, the negotiations also started. And they started in a way which is interesting and which I'd like to recall. There was immediately a talk of adopting a comprehensive agreement on investment. And please notice the formulation as a stepping stone for a comprehensive free trade agreement. We are not there yet. The comprehensive agreement for investment is as much as we have come, and actually as a paper. We also know that there were different rounds of negotiations for 7 years, 35 rounds of negotiation, which eventually led to the adoption as a result of a very determined push, particularly by Germany in the context of its presidency of the European Council at the end of 2020. What is the scope of the agreement? Well, the agreement, I would say that the scope can be analyzed both positively and negatively. Positively, it is about investment protection, but it is much more than that. It is also about market access for investment. It is about regulatory issues. Once the investor enters one of the partners. It is also about investment-related sustainable development. And fourth item, it is about dispute settlement, enforcement, and implementation of these substantive agreements. If the scope is already much more than any other traditional investment agreement, there are also certain areas which the scope does not comprehend. And it's also important to realize I would say, the limits of this agreement. It is not about import, export. It is not about customs duties. It is not a foreign trade agreement. It is not about setting up, a free trade agreement. It is not about setting up a customs union. There is provision for opening up in certain sectors, but there are also many sectors which are excluded from access. And I can just give 3 examples: audiovisual, air transport, and activities in the exercise of governmental authority. It is not about government procurement. The Europeans wished it were also about government procurement, but it is not, which means that the European Union companies cannot expect to rely on the agreement for a general access to bidding contexts in the different layers of the Chinese market. Foreign direct investment, on the other hand, remains subject to national security scrutiny. There is no such thing in the agreement as the end of the negative list of China. There is an easing of this negative list, which, by the way, China had also been making also against other partners. By the way, it is not sure what this implicates for other countries. In principle, nothing, with certain restrictions. There is also not substantial improvement of the Chinese access to the European Union market, for instance, as China would have wished in the energy sector. And it is not, and maybe this is important at this particular historical moment where the agreement has been suspended for other horizontal reasons, it does not mean to cover all areas of cooperation between European Union and China, those of more value charged, like democratic organization, open societies, not even, let's say, the human rights agenda. There are other settings in the European Union-China context for addressing these topics, which, by the way, are addressed at the different levels of the European Union-China cooperation. Then, what is the contents of the agreement? Expectedly, lawyers would say it is obligations against rights on both parties. But it is interesting to note, I believe, and only fair to say that in fact, it is a set of obligations and rights which overall are more likely to benefit mainly European Union companies investing in China. And why is this so? Well, because the European Union has already granted a broad access to its market to Chinese investors. They are in the European market as any domestic company. It is the other way around, which is not the reality. The agreement facilitates investments, particularly it will remove restrictions at the time of an investment by, for instance, European Union companies in China. In some sectors, not in all sectors of the Chinese economy, we have already seen that, but it is nonetheless very relevant, the list of sectors where China has admitted to liberalize its economy to the European Union born investment, manufacturing, automotive, cars. The German industrials could not be happier. Financial services, private health services, telecommunications, cloud services, business, environmental matters. I study a lot issues on water. Well, the big multinationals of water provision services could not be happier. Maritime transportation, construction, a little bit less so in the agricultural realm, not so much in fisheries, but still mining and energy. And in all these sectors, there is generally the lifting of different barriers to investment. For instance, on joint venture requirements, on equity caps, other restrictions I have already named, forced transfer of technology, for instance, boards of directors. And of course, while these commitments are substantive, of course, we should not ignore that China had already been removing some of these factors. Now, the agreement shall also remove restrictions after the European Union's companies are already installed in China, have invested in China. In there, the agreement aims to ensure a level playing field for these companies, addressing long-standing criticisms raised by the European Union companies. In regard to what? Well, in regard to this transfer of technologies, forced transfer of technologies, which is now definitely prohibited. Companies are recognized the freedom to license technologies to whoever they want. Equal access to standards setting bodies in China. There is more predictability of authorizations by different layers of regulatory and administrative authorities in China. There is a general rule on added transparency in regard to and procedural fairness in regard to the administrative authorities. And there are commitments not to impose nationality requirements in regard to senior management or board of directors, just to name a few examples. Very important, because of course, subsidies in China are generously granted to state-owned enterprises, and state-owned enterprises actually cover 30% of the GDP. There are rules on transparency of these subsidies, on the need to disclose information about subsidies granted to SOEs. And this is absolutely interesting because it is very innovative. You cannot find any of these from China in the context of its WTO commitments. There is the recognition that subsidies shall be increasingly scrutinized by interested parties, and there are procedures which are defined for that. There is a general rule that SOEs shall take decisions solely based on commercial considerations, and if this is not honored, there shall be mechanisms for address this. And in regard to the contents, I would also like to precisely recall that the agreement sets up a robust state-to-state dispute resolution mechanism and a novel monitoring mechanism, which comprehends firstly a consultation phase and then a recourse to an independent arbitration panel composed of highly qualified experts, which delivers decisions, but also, and which of course materializes this sense that these agreements are to be complied with, but also parties agreed to set up an institutional framework for monitoring the day-to-day implementation of the agreement and addressing issues as they arise. There is an oversight committee established at the level of Vice Premier in China and Executive Vice President for the European Union Commission, together with civil society, which shall be tasked for addressing issues as they arise. Now, there are also outstanding issues, but it is interesting to note that particularly the two most important ones, which are the investment protection standards and investment dispute settlement, which may or not move away from the ISDS traditional system, there is a time lag, time frame which has been agreed. Within 2 years, there is the expectation, 2 years after the signature of the agreement, which means starting at the beginning of 2021, at the end of 2022, the two parties shall come up with some response in regard to these specific standards, as well as to these alternative dispute settlement mechanism. Now, by means of a very quick assessment, I do realize that I should allow time for interaction with my dear public and the audience, as I the very first to be interested on. I would just say that the agreement does provide, I would say, a very valuable response to a very immediate need for, I would say, dynamization of investment flows on both ways to address the momentous challenges that these two very important economies are facing in the context of sustainable development ventures, in the context of climatic transitions, of digital transition. Investment can indeed be a tool for this. It is very necessary also for addressing the reconstruction needed by the pandemic. The agreement in itself is meritorious, but it is also, I would say, very important for what it sets as a kind of a precedent in terms of new topics and a new attitude for addressing problems which are outstanding, not only between the European Union and China, but major global governance issues. It sets a very high example, an agenda which is also auspicious in that regard. And that's why I believe, it would be indeed relevant to look at it carefully as a possible auspicious way of dealing with these momentous problems. With this, Mr. Davis, I turn the mic back to you, if I may. I thank
Sure.
for your attention, for allowing me to share these insights. But of course, now I would be at your disposal for a discussion, and I would very much welcome also sharing your points on this. Thank you.
Yeah. Thank you, Professor, for your insights into this agreement. And I think it's quite important that you do not only take us through the many legal aspects of the treaty, but also the limits of that treaties. I think when lots of people discussing these treaties, and they always talk about what aspects that would be developed, but they likely pay less attention to the limits. And could I ask a question for first myself? Because Professor, you said the EU side, it seems that their objectives are of wider scope, right? They do not only care about the inflows of investment, but also sustainability. These sorts of things is also high on their agenda. So, do you think that it would mean that because now the treaty has been frozen due to some developments, do you think that on comparison, the EU would be more eager to resume the process rather than the Chinese side does, or we can put it this way, Professor?
Well, as you know, the European Union is a very complex reality. Some people call it a non-identified political entity. And one of the features of this political entity is that it is composed of many voices. Voices which, of course, translate their own agendas, not necessarily strategically determined. In the process, once you have an agreement inked in the European Union, adopted between the partners, you have to devolve it to the member states on the one hand, and then to other institutions which have a saying also on the process of its conclusion. As you know, and you evoke that in very diplomatic terms, one of the bodies which has to look at this is the European Union Parliament, where different voices have expressed concerns, in particular to the implications of this agreement in the context of an agenda devoted to the protection of human rights. This is, let's say, a legitimate consideration, particularly in view of the reality of the European Union setting, but it is, I believe, having indeed a very tremendous impact on a tool which is in itself already provides some answers to this. Of course, the treaty itself could not, and actually it has been decided that it should not really outrightly address human rights issues as such. But by means of some of its provisions, for instance, whereby China pledges to adopt international labor organizations conventions, which it has not adopted thus far, there would be inroads into a higher level of commitment of China in regard to some of these human rights related to labor standards. This is an experience which has already proved to have palpable effects in the case of the relationship with Vietnam. The hope which was there in introducing these provisions in the agreement was that precisely this would bring, so to say, the European Union dialogue with China at this level to another height, which now seems to be compromised. So, frankly, I believe that if one would look at the agreement with a more strategic vision than, let's say, the one which is directly impacting the benefits and the concerns which are actually being expressed to suspend the agreement should also be the concerns to reaccredit this agreement. It cannot also provide more answers than a certain level. It is also, I would say, misleading to try to expect from an agreement of this kind a kind of thematic overload which actually leads to paralysis. A paralysis does not lead us forward. The agreement could lead us forward.
Okay, thank you. And we have a members of audience field want to ask a questions, and please go ahead.
Yeah, thank you. Thank you for the opportunity, and thanks, Professor, for the fantastic speech. And I have just one question. You know that under the current tension between US and China, and EU is kind of stuck in between, I guess. So, do you think the treaty may end up in a situation like only certain numbers of European countries agree to this treaty and not the whole European Union, or the Chinese or only parts of the treaty can be resumed? Thank you.
Well, I would say that the agreement is has clearly been impacted by the geopolitical context, and actually, I believe also that the decisive push that Germany gave to the agreement together with the Chinese presidency at the end of 2020 was precisely having already this prospect in mind. There was the notion that there would be a transition in the US leadership, and it was important to consolidate a number of gains that this instrument promised to materialize. It is very difficult to foresee how the current political setting where competition prevails over cooperation can lead to. my temptation, let's say, from a less geopolitical point of view, of course, is to suggest that even in a setting where one recognizes that there are different values represented, it is in the interest of all partners these days to find avenues for cooperation for addressing some of the topics of the global governance agenda. Both China and the European Union, but also other countries are in need of innovative investment, fresh flows of investment in both ways. This agreement did bear the promise of turning this into reality. Together, I insist, with certain guarantees that this investment would go hand in hand with an advancement in terms of introduction and legal introduction of labor and environmental standards. Moreover, also doubled by institutional mechanisms for making sure that in case of doubts as to the true conformity in reality, would lead to judicial independent bodies for analyzing these problems. I cannot see how much more ambitious one could be, but in this, the more so as when you look around and try to find, let's say, more advanced patterns, more advanced tools in other agreements, you are actually at odds for finding positive answers. And this is between two partners which are supposed, under this more recent geopolitical agenda, to be systemic competitors. If it is so, why not invest indeed on these forward-looking provisions and forward-looking mechanisms? I do believe that a little bit of looking more at the forests instead of the trees would actually lead to one answer only, and that would be that in the very interest of the interests and values which have determined the suspension shall be shelved and the process of ratification should be resumed.
And okay, thank you. And anyone else would like to ask a last question, perhaps? All right, then I think probably we can conclude our sessions.
Maybe Professor Wu wants to ask.
Yeah, perhaps Professor Wu want to ask questions. It's all right. Professor
Sorry,
Wu.
I have no questions. Because Professor.
Okay, so and then I guess that's that would be the conclusion of our webinar today. And thanks again, Professor Castro, for your important insights. But I do agree that there's no one can tell when the process will be resumed. When the process will be resumed, no one can tell, because that it is, as you say, it depends on a huge number of complicated geopolitical factors, right? So I guess we'll still having webinars on EU-China relations, particular again on this important treaty, because the process is still very much ongoing. And we look forward to have Professor Castro joining us again to share your new insights if possible. And right, Professor Wu?
Great.
Okay. So I guess that's it for
may I
today.
just
Yeah.
thank you?
Sure.
May I just thank you, Mr. David Zip and Professor Wu Mei, for this opportunity, and of course the Fortunius Society, prestigious society, for this opportunity for sharing my thoughts on this. And substantially, I would just end up precisely with your words, Mr. Ip. I believe that in face of, let's say, the surprise that this situation we are experiencing provides, I believe it is only important that different communities of people set their energies and intellectual energies. Our epistemic communities are under a duty indeed to share thoughts on this. And for that, I'm very grateful that you invited me for this and had the opportunity to interact with different members of your society and think on this matter, which is so relevant. I insist not only for the European Union and China, but possibly as a standard-setting opportunity for global governance in the world. We all aspire for a world of cooperation, even if competition cannot be erased.
Okay, great.
Okay, thanks a lot for food for thought.
Great.
Thank you. Okay, that's it, and see you again, and please join our next webinar. Bye bye.
Bye bye. Thank you. Thank you.